All right, good morning or afternoon, I guess, depending on where you're at. Again, today's Legal FB at Lunch session is going to be about Sentinel surveillance and capturing rapidly changing landscape using Sentinel surveillance methodology. And so for those of you who aren't familiar with Sentinel surveillance, this project was developed as a new legal mapping method intended to quickly identify, capture, and track emerging laws and legal innovations impacting public health. And the development of this project was supported by the Robert Wood Johnson Foundation. So Sentinel surveillance is a bit different from policy surveillance methodology, which I think many of you may be familiar with. So we'll talk a little bit about the differences between Sentinel surveillance and policy surveillance and why one may be a better fit for maybe a research project that you're interested in as opposed to another. And when thinking about how to identify what makes for a good Sentinel surveillance project, there are a number of different selection guideline criteria, and these were developed with a council of key stakeholders from various organizations, universities, government agencies. And so this council helped us to refine selection guidelines that we can then use to determine whether a law or a policy is maybe a priority candidate for Sentinel surveillance tracking. And so these are the 6 selection guidelines. The first being accessibility of the law. So whether the law or policy is available in written form that can be easily obtained for the jurisdictions that you're interested in researching. So if you're thinking about local level policies, school district policies, are those actually obtainable? And how would you be able to identify and capture those laws? Also, impact on health and health equity. So can your research team hypothesize that the policy of interest is going to have a significant impact on health-related services, or equity? And equity separately is a law or policy that has some kind of anticipated impact on equity. So whether that's health equity, racial equity, et cetera, that makes it a stronger candidate for tracking than those that do not. Rapid policy diffusion. So this policy is maybe spreading or has been endorsed or pushed by national organizations that are capable of promoting this widely. Factors here include when the law was passed, the number of jurisdictions that have the law, and also scalability. And then need for research. So there are more important questions about the implementation and impact of the policy, and a publicly available data set might facilitate this research. And finally, partnership potential. So is there a potential to collaborate with partners on some aspect of the Sentinel surveillance process? So can you have a team to help with research, coding, or tracking, or even dissemination? So these are all kind of considerations when thinking about a Sentinel surveillance project and what might make for a good candidate for conducting Sentinel surveillance. But I did want to kind of touch on the key differences between Sentinel surveillance and policy surveillance, and those largely being what the process for that looks like, right? So the process is really similar, I think, in terms of, when we compare it to policy surveillance. Generally, you start with scoping and background research, then go to develop your questions and answers. So much like policy surveillance, Sentinel surveillance, we're creating a question and answer set that we're using to track these variables. Research and coding, quality control, I think, is a bigger deviation from the standard policy surveillance process. And then finally, regular tracking and updates. So the process flows really similarly to policy surveillance, but starting with scoping and background research, I think a big difference here is when you're considering the selection criteria. So whether or not there's an interest in understanding how this policy area will impact health equity, the extent to which that you can collaborate as you're thinking about how you'll conduct this project. Question development. Policy surveillance tends to be much more in depth when we're thinking about the variables that we're interested in capturing for a particular policy area. But with Sentinel surveillance, we're really trying to focus on the most critical features of the law. So as we see a particular area of law or policy that's new or emerging or rapidly changing, we want to really be able to identify those in real time to the extent that we can. And so being able to identify those most key features of the law, I think, are really important. And in that sense, it can tend to make for a more high level data set as opposed to policy surveillance. As far as research and coding, we have limited to no redundancy, and that's when we're thinking about the actual research itself and also the coding. So in that sense, it makes for a much quicker production of data set, but also, we want to take into consideration the fact that without redundancy, we want to be able to implement quality control measures in other ways. And so some way we do that is by having research and coding spot checks. So maybe the supervisor is culling through the research and coding and just spot checking, or doing a cross comparison with other available data. And so, of course, the limited quality control doesn't make this right for maybe a full-blown evaluation. However, it does allow us to produce data sets much more rapidly and in real time. And that in and of itself has its own value too. So I think, considering the goals of your project or something where you're really, thinking about how to implement quality control and to what extent you want to have quality control as part of your project. And then regular tracking and updates. So this sort of allows you to expand upon, if you're conducting a Sentinel surveillance project, thinking about broadening the scope or including more jurisdictions over time. So Sentinel surveillance is really when we're thinking about these new emerging laws cropping up, and oftentimes that only happens in, a handful of jurisdictions. But if this is an area of policy that's, gaining a lot of traction, as we'll see with the projects our speakers will be talking about, maybe thinking into the future about tracking these laws over time, how they change, and how more jurisdictions adopt them over time. So this is really the process of Sentinel surveillance. Like I said, very similar to policy surveillance generally, but overall, it's much more high level, less quality control, but is really a good starting point to allow us to really identify areas of law or policy that are really novel. And the general goals of Sentinel surveillance are to track the state of the law in question and answer format, much like we do with policy surveillance. But again, the difference here being that we're focusing on high level critical features of the law rather than being super in depth. And also, we want to be sure that these are questions that you can maybe expand upon moving forward. So for example, if you're considering creating a future policy surveillance project that you can evaluate later on. And Sentinel surveillance is really no different from policy surveillance in terms of those who are really interested in this work. It can be valuable from a policymaking perspective or advocacy when we're really trying to get a good understanding of what these new and emerging laws or policies are doing. And also being able to expand upon these moving forward for evaluation. So there's a number of different reasons Sentinel surveillance might be a more valuable project if you're interested in tracking something that maybe is a newer area of policy, or there's a new kind of feature of something that you want to get a better understanding of. And so to give you kind of a better idea of what some of these projects might look like, I'll turn it over to our first speaker, Katie Moran-McCabe, and she's one of our lead law and policy analysts. Katie led the development of the Sentinel surveillance of emerging laws and policies legal mapping method, and led the creation of 2 data sets built using that method. So the Sentinel surveillance of emerging laws limiting public health emergency orders data set, which we'll hear a little bit about, and the Sentinel surveillance of emerging drug decriminalization legislation data set. I'm also going to introduce Adrienne, who will be speaking after. Adrienne Garashi is also a lead law and policy analyst at the center, where she leads multiple multidisciplinary legal epidemiology studies tracking and evaluating the public health impact of laws. She's an attorney, academic researcher, and social justice activist. Her expertise is in sexual and reproductive health laws with a focus on US and global abortion access. Her work also includes intersecting issues of health equity, such as housing inequality, healthcare access, criminalization, and immigrants' rights. She maintains annual updates to the center's abortion law database and is an expert on the rapidly shifting legal landscape of abortion regulation. So with that, I will turn it over to our first speaker, Katie.
Okay, thanks so much, Alex, for that great introduction to the process. And thanks to everyone for joining today. So as Alex mentioned, I'm going to talk about one of the data sets that we created using the Sentinel surveillance process, which is the Sentinel surveillance of emerging laws limiting public health orders. Next slide, please. So this data set tracks laws that limit the authority of a governor or a state health agency or official regarding public health emergency orders. It's a longitudinal data set covering all 50 US states and DC, and it includes all laws that were enacted since January 1st, 2021, and were effective on or before May 20th, 2022. And just a big thank you to ASTO, the Association of State and Territorial Health Officials, for providing research for this data set. We'll talk about more in just a minute. Next slide, please.
Oh, sorry, one second.
Sure. So we knew that collaboration was going to be important in the Sentinel surveillance process. So as Alex mentioned, one of the first things that we did in developing these methods was to create a council of key stakeholders from various organizations made up of folks with a variety of expertise who helped us to, number one, refine our topic selection guidelines that Alex just discussed, but also highlighted topics for us to consider tracking. And the issue of emergency public health authority was one of the topics at the forefront of issues on people's radar at the end of 2020 when we were in the thick of developing these methods. Throughout the COVID-19 pandemic, legislators in almost every state had introduced bills that would limit state executive authority regarding the use of emergency orders to respond to the COVID-19 pandemic, and in some cases to future public health emergencies. So as states were starting to enact some of these bills, which had the potential to substantially impact public health, this seemed like a topic that was really ripe for Sentinel surveillance tracking. And as I mentioned, the folks at ASTO helped us with this tracking. They were tracking the same topic, so they would send us their reports with the legislative activity that they were tracking and all of the bills and laws that they had captured. We took that information and coded the laws that were in scope in order for us to create our data set. So this partnership really allowed us to focus on the coding of the laws and not have to worry about the research, which allowed us to create and update the data set much more quickly than we would have been able to otherwise. So collaboration is definitely something worth exploring if you're thinking about using Sentinel surveillance to track laws and policies. Next slide. Okay, so now let's dive into the data set. So this is a snapshot of the dataset homepage, just to give you a sense of how this looks on Law Atlas. So you can find this data set on lawatlas.org, and we'll give you more information on accessing it in just a few minutes. But the data set is published with interactive maps and tables that can be queried by jurisdiction or by legal variable. So you can click on a state on the map and then see the answers to all of the coding questions for that state. Or you can click on a question, a legal variable on the left side of the screen and see the states that meet the criteria selected. Next slide. So here you can see the 21 states highlighted in yellow that passed a law as of January 1st, 2021, that limits state executive authority regarding public health emergency orders. And again, this map shows laws that were effective as of May 20th, 2022. Next slide. This chart shows the progression of states that enacted these laws from January 2021 through May 20th of 22. So you can see most of the movement was between March and July of 2021. So 5 states in March, 9 states in May, and then up to 18 states in July. The states that are labeled in yellow in each of the bars, those states enacted laws that became effective since the date of the previous bar. So, for example, if you look at the second bar here, you can see that Idaho, Montana, North Dakota, and Utah all enacted laws that became effective between March 20th and May 20th of 2021. So this just gives you a sense of the rapid movement in enacting these laws in the spring and summer of 2021. Next slide. On this map, you can see the 17 states that limited authority of both the governor and a state health agency or official. Next slide. And just a couple of other interesting findings to share. There were 14 states that limited the authority of a governor and a state health agency or official, and a local health agency or official. So for each of those entities or types of individuals, the data set captures how their authority is limited at a fairly high level. So the 4 variables you see here on the slide are potential responses to the coding questions, and both Louisiana and Utah limited the authority of state health officials in all of these ways. So just to sort of run through them quickly, issuance of emergency orders is restricted. This would be, for example, requiring the governor to approve orders issued by health officers, or requiring that executive orders be submitted to a legislative council for review. Duration of emergency orders is limited. This is when the law explicitly limits the amount of time that an emergency order or state of emergency can be in effect. So, for example, limiting it to 30 days or 60 days, something like that. Orders may be terminated by the legislature. This is when the law explicitly allows the legislature to terminate an emergency order issued by a health official. And then we also captured any restrictions on the scope of emergency orders. So next slide, please. So restricting scope was the most common limitation imposed by states. Scope limitations were coded when the law placed a restriction on the substance of an emergency order. We'll talk about some examples in just a minute, but this map shows the 12 states that imposed restrictions on the scope of a governor's order and the scope of orders issued by a state health official. Next slide. So just to give you a sense, some examples of the types of scope restrictions we saw, prohibiting state health officers from mandating use of face masks, prohibiting mandates for folks to receive a COVID-19 vaccination, prohibiting the governor from inhibiting the gathering of people for any religious, civic, or commercial activity, and also prohibiting a state disaster plan from compelling a business to deny access to customers. We did not track all of these details in the data set itself. Again, because this is a Sentinel surveillance data set and we wanted to try to update it as quickly as possible, we had to limit the questions to really only capture the most critical features. I will mention, though, we do have another data set that I'll talk about in a minute that captures some of the specific measures that are addressed in laws that are similar to these. So capturing whether the legislation addresses masks, vaccines, businesses, schools, etc. Next slide. Just changing gears a bit, I wanted to just quickly show you another data set that we created using Sentinel surveillance methods. So this is the Sentinel surveillance of emerging drug decriminalization legislation. This data set captures legislation, both laws that have been enacted as well as bills that were introduced and not enacted, that decriminalize the personal possession of most or all controlled substances. And this is a longitudinal data set as well that tracks movement in both laws and bills from March 15th, 2022 through August 1st, 2022. Next slide. So this map shows the 8 states that introduced legislation to decriminalize personal possession of controlled substances, and then the status of the bills in those states. So you can see Oregon in yellow, the only state so far to have enacted one of those bills into law. And then the states in green, Kansas, Maine, Maryland, Rhode Island, Vermont, excuse me, and Washington introduced legislation, but it didn't pass. And then in Massachusetts and New York, bills were still pending as of August 1st, 2022. Next slide. So this table shows the key features that we capture in the data set. In the data set itself, we only track these features for enacted laws, so only for Oregon. But this table comes from a policy brief that was written by my colleague, Deanna, who did the bulk of the work on this data set. And we wanted to show which of these features could also be found in the pending bills in New York and Massachusetts. So you can see in that first column, we list the different elements of the legislation that we captured. And then you can see which states had those provisions in their bills. So you can see the Oregon law has all of these elements except for a mechanism to vacate a prior conviction for drug possession. The policy brief that we published with this data set has additional details and reviews some of the initial analysis of the Oregon law. So I would recommend taking a look at that if you're interested in learning more on this. Next slide. So here's how you can access the Sentinel surveillance data sets that I just talked about. You can visit this the webpage on lawatlas.org, or you can scan the QR code here. On the homepage, you'll find a brief description of the Sentinel surveillance process, links to these 2 data sets. And then on the homepage for each data set, you'll see the interactive maps and tables, the research protocol, data pages, and code book that are published with the data sets, as well as the policy brief that gives just a summary of the legal landscape, discusses evidence and policy recommendations, as well as thoughts on a research agenda going forward. Next slide. And for anyone who is interested in the legislation affecting public health authority, I wanted to highlight some related data sets that we just released. These are 6 data sets that we created using a process based on Sentinel surveillance methods, and were also created in partnership with ASTO, as well as the Network for Public Health Law. So each of the topics listed here is its own data set. All of them are longitudinal tracking bills that were introduced between January 1st, 2021 and May 20th, 2022. And that the data set regulating public health measures, that's the one I mentioned a minute ago that captures the specific measures that were the subject of the bill. So for example, vaccine measures, mask mandates, businesses or school closures. So you can scan the QR code here or visit Law Atlas to explore these data sets if you're interested. Next slide. And then I just wanted to mention those 6 data sets were created as part of the Act for Public Health initiative, which is a partnership made up of the groups you see on the slide here. And it provides direct support to public health departments through consultation, training, legal technical assistance, research, and other resources to address legislation that weakens the ability to protect communities. So again, you can scan the code here or visit the Act for Public Health website and find out more about what that offers. Next slide. So that's it from me. I think we should have some time at the end for questions, but please also feel free to reach out at the email address here. And thank you so much.
Thank you, Katie, for that great presentation. Like she's mentioned, we will have some time for questions at the end. So I'll turn it over to Adrienne.
Hi, everyone. Thanks so much for being here. I'm going to talk about our ongoing efforts to track legal developments post-Dobbs on the state level. Next slide. So I'm assuming most of you have heard about this case, but just in case, the Supreme Court back in June overturned Roe v. Wade and the protections that came with it. And so since then, we've seen a rapid shift in the legal landscape of abortion. Next slide, please. So just to give some background on what things looked like under Roe. So for the past 50 years under Roe, the landscape was already deeply fractured based on the holding in Roe and Casey's undue burden standard. So not only did state statutes and regulations vary sharply from state to state, but they added complications of litigation and case law, AG opinions, all of which were largely based on Roe. And so states were largely free to restrict abortion as long as it wasn't an outright ban, such as the one in Dobbs. And other types of restrictions were upheld, such as mandatory waiting periods, parental involvement requirements. Also, there was no sort of guarantee to funding or access. So that meant insurance and Medicaid bans were all upheld, as well as really strict facility and provider requirements. And as we know, these legal barriers disproportionately impact communities already marginalized from that care. Next slide, please. So even before Dobbs, we saw states such as Texas encroaching on what was supposed to be settled constitutional law regarding abortion. So once the Dobbs decision officially came down, chaos was unleashed, and the leak had also emboldened states to start acting. A major reason why abortion was able to be banned so quickly and essentially overnight in many states was because of existing laws called trigger bans or trigger laws, as well as pre-abortion bans that were never repealed and were still on the books. And so while under Roe, they weren't enforceable, as soon as the protections of Roe were gone, those laws did become enforceable, which is why there was so much questions about whether abortion was banned or not in these states. And so because much of the existing case law was, of course, contingent on Roe and Casey, now there's all sorts of legal questions and potential new challenges. And as I'll talk about in a little more depth, a really sharp divide has emerged among states moving to either ban or restrict the majority of abortions, and those trying to sort of be a shelter for abortion seekers and to try and really protect and expand access. Next slide, please. So I'm just going to talk a bit about how we applied the Sentinel surveillance methods that you've been hearing about in this post-Dobbs context. Next slide, please. So given the existing regulatory framework of abortion under Roe, which often included convoluting and overlapping requirements by each state, Dobbs was like adding gasoline to the fire. So in an effort to try and keep pace with these rapid legal developments and create a foundation for research on abortion post-Dobbs, CPHLR and SFP, Society of Family Planning, collaborated to publish this new resource. And the database has a focus on laws affecting abortion service delivery and the criminalization of abortion care, tracking changes in the law immediately after Dobbs and 1 year out. And the goal of this data set was to meet the urgent need of supporting timely and critical research on the impact of Dobbs. And it's a partner to SFP's We Count project, which collects abortion data state by state. Next slide. So you just heard about the methods that we used for this database. The data collection starts from June 1st, so a little bit before Dobbs, and will be updated throughout 1 year post-Dobbs. And so the next release will be actually early next month, and it includes statutes, regulations, case law, AG opinions, and in some cases, executive orders across the 50 states and DC. So we identified key areas of abortion regulations that were most likely to be impacted by the Dobbs decision. And we also consulted with leading experts and researchers in the field to make sure that these variables would be of immediate interest and use. Next slide. So a little bit about the types of laws and policies that we included in this data set. We won't have time to get into all of these, but I'll show you just a few examples. So we included, of course, abortion bans, and that includes total or near total bans, different gestational age limits, so-called fetal heartbeat bans, method bans, reason-based bans. We also included the trigger bans that I was speaking about and related certification. So when this was all unfolding, there were questions about sort of how long it would take for trigger bans to actually take effect. So in some states that could have been immediate. In other states, there were provisions that said, you know, something like 30 days after certification by a court or something that Roe v. Wade had been overturned. We also included restrictions on medication abortion, telehealth. We focused on the different types of penalties that people could face for violating abortion laws. And we also thought it was really important to include the different types of protections and proactive policies that we were also seeing, such as the interstate shield laws and other protections such as a codified right to abortion, increased funding, insurance coverage, and some data privacy measures. And so for this next update that will be released in March, we've added quite a few variables as well as we see the landscape sort of shifting and evolving. So we're also going to be including medication abortion certification and reporting requirements, restrictions and protections explicitly aimed at self-managed abortion, who penalties apply to and whether pregnant people are exempt, explicit rights for fetal personhood, additional protections such as training programs for providers and reproductive rights task forces, as well as ballot measures restricting or protecting abortion. Next slide, please. So yeah, you can just keep clicking through to see this really heartbreaking change. So this data actually was pulled from our existing state abortion laws database, which has been tracking legal developments since 2018. So that was the change that you saw sort of over that four or so years period. And so while currently about 19 states banned nearly all abortions with limited exceptions, these weren't not in effect in 7 states. And you can see the reason that the colors changed so quickly was because of those trigger bans and pre-Roe abortion bans that I was talking about, which essentially allowed abortion to be banned overnight. And while we have sort of mapped out with the dots, like which ones are subject to legal challenges, again, there are questions on the ground about whether abortion is legal or not. And so when there's questions about enforceability of abortion bans, that often means that the reality on the ground is that there's no access, such as in. Next slide, please. So as I mentioned, another focus that we really wanted to hone in on was looking at the different types of penalties for different actions related to abortion. So as you can see, most states have some type of criminal penalties for abortion. They also have civil penalties as well as licensing sanctions and things like that. While most of these penalties target abortion providers, states may also criminalize certain actions related to abortion, such as assisting with an abortion, which is 6 states, providing information on abortion, which is in Mississippi, and providing abortion drugs, which is in 20 states. And this is right now as of our latest update, which is the end of August, but this will all be updated again through February. So additionally, 5 states criminalize the person obtaining an abortion, either directly or by not explicitly exempting them. So meaning the pregnant person could potentially be at risk for prosecution. And so we know the law may not accommodate for self-managed abortion. We also know that pregnancy is criminalized even if the laws don't explicitly state this. So things like fetal assault laws, child welfare, FUD. So of course, it won't be surprising in this post-Dobbs context that legislatures will continue to consider measures criminalizing abortion seekers and helpers, and trying to limit out-of-state access and other types of more explicit changes. And that's why we have decided that we're going to look, more explicitly at self-managed abortion in this next update. Next slide, please. So on to the less depressing news. So again, as of the last update, we saw 15 states enact these interstate shield laws. These laws aim to protect patients, providers, and others from out-of-state liability and prosecution for abortion care that's legal in the receiving state, but may not be legal in the state where people are traveling from. And so this is an entirely new type of policy response that we saw specific to the post-Dobbs context. So the very first interstate shield law was passed I believe, in May of last year, and that was Michigan. And so since then, we've seen these sort of spread. Now, some of these, the majority of these are enacted by executive order, but some of these are codified. And so on the other map, we see that states also had existing protections under Roe, and that of course increased under Dobbs as well. So states codifying the right to abortion. And we saw, because of what happened with all of the case law and Dobbs, why it's so important, again, to codify these protections as well as to put them in state constitutions. So other types of protections, as I mentioned, captured by the database include expanded provider eligibility, mandatory insurance coverage, increased funding for abortion, clinic protections, and data privacy measures. And of course, it's important, just as important, if not more, to track sort of these proactive policy responses and see how they're being adopted and amended as we continue looking at the effects on abortion access. Next slide, please. So as I mentioned, we're going to continue using the Sentinel surveillance methods to track these legal developments and sort of expand the data set and build on what we're seeing on the ground. And we'll be doing that through 1 year post-Dobbs. We also have updates to the state abortion laws database. This really is a resource that allowed us to move so quickly to then create the post-Dobbs data set, because we had seen for years sort of the different legal pressure points and issues that were going to become even more relevant if Roe was overturned. And yeah, if you're interested in accessing the data set, feel free to look at that. And as I mentioned, our next update with expanded variables will be coming out early next month. So that's it from me, and I look forward to hearing your questions.
Thanks, Adrian, and thank you, Katie. I'm going to stop sharing my screen now. If anyone has any questions, again, feel free to throw them in the chat or the Q&A function, I think, as well. And I can see. I can also start with a question I had for both of you. Obviously, we talked a little bit about the sort of criteria when thinking about what is a good fit for Sentinel surveillance, but I guess just generally thinking about each of these projects that you've discussed, why did Sentinel surveillance seem like a better fit or a better approach as opposed to full-blown policy surveillance methodology? Either of you want to speak to that?
I can start, and then Adrian, if you want to jump in. I think, and it may be similar to for both of us, but for the laws limiting public health authority, I think just because legislation was being introduced so quickly, and not only that, but then laws were being enacted so quickly, and also because it was a hot topic that was really, relevant to a lot of people. This was, really a great fit for Sentinel surveillance, so we could just get the data set out there as soon as possible, rather than using policy surveillance methods, which would have, taken much longer. So we were really able to sort of get the information out there, much more quickly, which I think was, really important given the topic.
Yeah, similarly, I mean, we knew Dobbs was coming. We didn't know exactly what was going to happen, but we knew we needed to be prepared for that. And so this was a way to make sure that we could just get that started, like right before the decision, and to be able to have like a really high level overview of what these big changes and trends were, while also allowing us to sort of shift as needed, to add things that maybe we didn't think of or we weren't seeing before, and then hopefully opening the door for anyone that sort of needs to dive deeper into these areas, laying the foundation for that research.
And I guess a follow-up question, and this also might be a similar answer for both of you, but what were maybe some of the challenges that you came across as being part of a team working on these projects, but also, you both managed these projects. So what were maybe some of the difficulties you had in conducting each of those projects?
I'll start. A couple of things, I think. So one, I'll mention, I think with Sentinel surveillance, trying to balance speed and accuracy. So essentially, like trying to determine how much quality control to use can be difficult. We're with Sentinel surveillance using much more limited quality control than with policy surveillance. But obviously still want the data to be as accurate as possible. So trying to work quickly and get the information out there while still making sure that we're capturing things correctly. And inherent in that is deciding how much quality control to use. So that was a challenge. I'll stop there if Adrian wants to jump in.
Yeah, I mean, I definitely agree, especially in the area of the abortion regulations. We know that whatever data set that we put out tomorrow, it's going to be something different. And so just needing to sort of, I guess, just understand that and make sure that we're accurately tracking the changes over time, and knowing that, that tomorrow will be captured in the next update. And so just having to sort of be patient with that, as well as knowing that there's so much that is changing and relevant in terms of abortion law particularly, and knowing that we won't be able to go in depth with all of that information, but so really trying to be selective about what are like the most important pressure points and trends that we want to capture.
Thank you. It looks like we got a couple of questions in the Q&A. First one, could you turn a data set built using Sentinel surveillance methods into a full-blown policy surveillance data set? Do you have plans to do that with any of your examples? I guess I'll let either of you speak to that.
Yeah, so it's a great question, and I think that's sort of one of the goals of Sentinel surveillance is that it could be a really good sort of jumping off place for a full-blown policy surveillance data set, particularly if it looks like several jurisdictions are starting to enact these laws. So yes, I think certainly you could take any of these Sentinel surveillance data sets and easily turn that into policy surveillance using the more rigorous quality control methods, adding questions if you want to expand the scope to capture more detail on the topic, then you could certainly just add new questions. Typically policy surveillance data sets have capture more legal variables than the Sentinel surveillance data set. So that is definitely not only something that can be done, but it would be great, I think, to see that happen.
Yeah.
Sorry, go ahead.
I was just going to add that we don't have immediate plans for the post-Dobbs data set yet, but we've already seen that happen with our state abortion laws database. So when we first started that database, it was not longitudinal, and that's something that evolved over time. And then we were able to, from there, have those data sets as starting points that shaped other types of like longitudinal projects looking at abortion laws, as well as informing the post-Dobbs data set. So I think that that's something that will be picked up at some point.
Another question, is the data codified numerically so that it can be compared or combined with health data, for example, comparing abortion restrictions to morbidity, mortality? And has there been any work using GIS software to map this data? Well, for one thing, I'll add that all of our data sets that you see on Law Atlas come with the downloadable data. So that's in statistical format on CSV file, and then as well as the summary data. So in that sense, our data is available numerically. And then I don't know if you want to speak to that question at all, Adrian, specifically as it relates to abortion restrictions.
Yeah, sure. So for abortion policy, and I assume probably any of these topics, I think one of the most important things you can do is to collaborate and to have a multidisciplinary team. So, there's a lot of nuance within these policies. So consulting with, the people who have created the data, us right now, is something important to be able to ensure that you're going to have all the variables you need to look at the outcomes that you want, to make sure you're answering the right research questions. When creating these legal data sets, there's so many decisions that come into how to code things and categorize things and define things, all of which is listed in the protocol, but it's extremely helpful to just speak to us to make sure that you're using the data in the most efficient way. And then, of course, from there, you want to consult with all different sorts of perspectives in terms of making sure that, the outcomes that you're looking at are the most valuable ones.
Thank you. And I think this is actually similar to that question following it. Could you speak to how to integrate Sentinel or policy surveillance with health outcomes research, particularly with regards to abortion policy? So I think you just spoke to that. I don't know if there's anything you want to add, but thank you all for these questions. Any other questions for Adrian or Katie? It looks like we have just a couple minutes left. Right, I think we answered everything in the Q&A. Thank you, Adrian and Katie, for those presentations on both of those projects. I also want to mention that our next Legal Epi at Lunch session will be April 11th, talking all things Monocle. So if you're interested in talking more about Monocle software itself and using it, that will be again on April 11th at noon Eastern. So I think we don't have any more questions. Thank you again to our speakers, and thank you all so much for joining us today for this session. Have a great rest of your afternoon.